The 8:30 topic on this evening's agenda is entitled Revisions to Village Code Regarding Property Maintenance and Inspection and Local Code Enforcement. Our intent, Stuart and I have discussed this, is to make this a reoccurring topic until we really get it buttoned up. And that, as you know, is a work in progress, and we're going to talk about that a little bit tonight. But before Stuart updates you on what he's accomplished in the last week in this ongoing effort, I thought it appropriate to read to the board and so the public can get a sense of why we're doing what we're doing. I'd like to read a text I received by our code enforcement officer with regard to one of our latest buildings that required placarding and did not allow people to inhabit the building. It's regarding something that happened just this past Monday night. And I'm going to obviously edit out some details, but I did discuss reading this with Stuart, and it's okay to do that. It's to me from our code enforcement officer. I was called out by the Ossining Fire Department at about 10:30 p.m. Monday night because of an electrical fire. The fire started because of a short in a surge protector used in the attic, which was not code compliant for living space, and there was no record of the space to be approved for conversion into a habitable living space. There was one man, one woman, and an infant baby living there. The house had numerous electrical violations, including exposed wiring throughout the home and spliced extension cords to create lighting fixtures and switches that were stapled to the sheetrock on the walls and tapped into outlets. Upon entering the kitchen, there was the smell of gas. The fire department used a device to confirm the presence of gas. The fire chief contacted Con Edison to alert them. They arrived about a half hour after that. They confirmed that there was a gas leak and immediately shut the gas service to the home. Due to the electrical conditions, Con Edison informed me that they would have a crew come back to disconnect the electrical service as well. I called the water department to come out to turn off the water service to ensure of no broken pipes due to potential freezing while the house was unoccupied. A placard indicating that the house is not habitable was placed on the door. The residents of the house informed that they had family members that they could stay with until all the violations were cleared. The next morning, I received a call from the Red Cross indicating that the owner, Mrs. Thompson, reached out to them for assistance. I informed them of the situation concerning the house. They told me they would make a record of the situation and attempt to assist any of the residents that required help. Also, the house was registered as a single-family home. So this is unfortunately not uncommon, but it will be the never-ending goal as we go through this process of the adoption of 1203, which Stuart's going to go into a little bit more now, and all of the code revisions and the efforts that we're making in code enforcement and the building department and the permitting process. We're not going to stop until this stops. Stuart?
Thank you, Paul, and good evening, Mayor and members of the board. The amendments or revisions that we propose are very broad and cover, I would say, probably 6 or 7 chapters in the municipal code. In 2015, the board approved amendments to Chapter 91, adopting the Uniform State Code. And the first thing that we propose to do is to slightly amend that, because the Uniform Code now includes both the Uniform Code, which is all the international property codes, maintenance codes, and things like that, but also the State Energy Conservation Code. This becomes important because all buildings now must be compliant with the State Energy Conservation Code, and indeed, even though we will be proposing that 1203.3 be added to the Villages Code, I am advised that by the end of this year, 1203.3 will itself be amended to put in specific references to requirements under the State Energy Conservation Code in terms of what must be done with regard to that code. But we're not going to wait until that amendment comes in. We have proposals to go through, and I just want to go through some of them with you. Chapter 95 of our current code is the Building Demolition Code, or the Building Demolition Code of the Village of Ossining. The proposal will be to rename that to the Unsafe Building and Demolition Code of the Village of Ossining. That's because under 12033 there must be a specific section that relates to unsafe buildings and what occurs with unsafe buildings, how the buildings can be placarded, the reasons for the placarding, and the emergency actions that can be taken by building inspectors or code enforcement personnel. I'm going to use code enforcement personnel as a generic term here. That will include our assistant building inspectors as well as the code enforcement officers that we have. But that's just for purposes of how that's how the code has it. But under the unsafe building code, the provisions will effectively allow a determination that a building is considered to be unsafe. If a building is unsafe, it can be placarded if it is found to be an emergency situation. And the placard is simply going to be, this building is unsafe and its use or occupancy has been prohibited by the building inspector or by the code enforcement officer. That's all the placard has to say. I've discussed this with Lynn Brooks Avni, and those are the placards that in fact will be printed, and those are the placards that will be going up. I just want to distinguish that placard from the placards that are required in a fire situation. Those are different types of placards. We'll deal with those at a different time in terms of what they have to say. They have much different language, and those are more specifically in the case of vacant buildings to warn firefighters if they're going into a building that there may be areas that have not been checked out and they should be aware of where they have to go. And it actually gives them specific directions as to where they should go in a building. That's not the type of placarding I'm talking about. We're also looking to revise Chapter 114, which deals with electrical standards. Back in 2015, this board approved changes to the plumbing code, which is Chapter 201, specifically removing those provisions that dealt with licensing of plumbers by the village. Similarly, we would propose that the licensing provisions with regard to electricians by the village be removed, because that is now the responsibility of the County of Westchester. So anything that relates to licensing is not handled by the village, and all the codes and all the fees required for such licensing would be deleted from our fee book with regard to that. The most significant changes that we're going to propose will be to Chapter 162, which is the Housing and Property Maintenance Code of the Village of Ossining. And most specifically, what we would propose is revision to Article 6, which would now be considered administration and enforcement. This is where 1203.3 will come in. And briefly, for the board and for the members of the public, 1203.3 is a regulation promulgated by the state of New York pursuant to the executive law, and every municipality must meet 1203. We can exceed 1203, and I just want to be clear on something. There's a difference between enforcement and administration and code requirements. For purposes of Section 1203, which I'll go into, which is enforcement and administration, if the board decides it wants to be more strict than what is in 1203, they are free to do so. For example, the 1203 calls for triennial fire inspections of certain buildings and annual fire inspections of others. If the board deemed it appropriate to do those fire inspections, all of them annually, that's fine, as long as you would have the manpower and the ability to do that. That needs to be contrasted with the code in terms of what you need to build your house, what you need for plumbing. In those circumstances, the municipality may not have a more stringent standard unless the state has so approved it. The best example is in the case of Ossining in 1990. Ossining proposed a sprinkler law which at that time was more stringent than the state's. One of the things that I have asked the building department to look into is to determine whether the sprinkler statute as currently promulgated in, I believe it is Chapter 162, is in fact now more restrictive, equal to or less restrictive than the current state sprinkler code. Because back in 1990, the state didn't have its own sprinkler code. The state does now because it's adopted the international codes. And so that's something that has to be determined. So I just wanted to be clear that if we are looking at a code section That's something that would require approval from the state to be more stringent. In terms of enforcement and administration, we can effectively be as stringent as we want to be. There's no restriction on that. We just can't go below the floor that the state has set. But with regard to administration and enforcement, effectively, the key points to note here are that building permits, according to the state, are not required for every type of construction that is done. And one of the things that I've asked the building department to advise is the state provides a list of 12 different types of construction for which building permits are not required. The building department can make a determination that they want to follow all of those, none of them, or some of them. I know, for example, that I believe we do not require permits for installation of swimming pools that are less than 24 inches in depth and are installed entirely above ground, kiddie pools, for example. And that's listed here. But there's a whole list of things in here. And that's something I'm working with the building department to make sure that we're consistent with them. Same with regard to time limits or the number of plans that have to come out. But the most important changes that we will be seeing here relate particularly with regard to two areas I want to go into, and the first are operating permits. In our schedule of fees, we do have a fee for operating permits. We need a specific ordinance that relates to operating permits. And according to 12033, an operating permit is required, and it's required for the following types of buildings. Buildings that manufacture, store, or handle hazardous material in excess of certain quantities. Buildings that where hazardous processes and activities, including but not limited to commercial and industrial operations which produce combustible dust, are located. Buildings that maintain pyrotechnic devices. Buildings with one or more areas of public assembly with an occupant load of 100 persons or more, which is probably the most likely to apply within the village. And there are other buildings if the village so deems it appropriate. But these operating permits are mandatory. And the way that the 1203 is written is that these particular venues will have to be inspected before the operating permit can be issued. This would apply to houses of worship if they're over 100. And again, the 100-person occupancy is what the state's minimum is. If you wanted to go make it 50, you could do that. That would be a determination to be made by the board. But there will have to be an operating permit application that will have to be developed, and we'll do that in conjunction with the building department so that we can put that together. The state recommends that these operating permits either exceed 1 year, be at a minimum of 1 year, not to exceed 3 years. And the question will be, will it require multiple inspections each time that the operating permit has to get renewed? That would be a determination that the board could make. But the operating permits have to come in. I don't have the fee schedule in front of me, but as I said, there is a fee that is associated with operating permits. I have asked the building department to provide a rough approximation of how many venues we are talking about that would actually be subject to operating permits. We counted a few off in our heads, but that would be exceedingly rough. So I think it's important that we figure that out. It does not include schools, okay, because schools are not subject to 12033. So we are looking, however, it would be houses of worship or other locations. Perhaps some of the restaurants that we're talking about here, anything would require the operating permit. So we will, that will go into 1203. The next significant issue will be fire safety and property maintenance inspections. We do have in our code currently Chapter 133, which are fire hazard inspections. The fire hazard inspection section is different than the fire safety inspection we're talking here, because the fire hazard inspection is a circumstance where the chief, deputy chief, assistant chief sees something. He can report it to the building department, and they can then conduct an inspection, or the building department can do it itself. It's not a regularly scheduled inspection. These fire safety inspections, however, under 12033 are required. They're mandatory. and how often they occur at a minimum for structures which contain an area of public assembly, and that's not with a limit of the number of people. That inspection must be performed once every 12 months. For buildings or structures being occupied as dormitories, which I don't think we have too many here, although we would have to check, again, once every 12 months. For all other multiple dwellings or non-residential buildings and structures, they should be performed not to exceed every 36 months. This is one of those areas where I mentioned that if the board believes it appropriate to have those inspections conducted more frequently, they can be. The key is the ability to get those inspections conducted. You don't want to put in a number and then not be able to actually do the inspections. But these fire inspections will be undertaken. One of the things that Planning Director Avni has been looking at is, in fact, how to schedule these fire inspections over a 3-year period. We've actually gone out to 2019 to see how to do it, how often they can be done, and I'll invite Lynn up so she may be able to just help us out. I think the calculation was anywhere between 6 and 7 a week they may be able to do in terms of manpower and things like that, but I'll let Lynn help out with that. But the fire safety and property maintenance inspections are important. It also should be noted that this is not the only type of inspection that is provided for under 12033. It's pointed out that inspections can be performed if the owner of the property wants an inspection. I actually had someone come in yesterday who is in what appears to be a lawsuit regarding his estate, or his father's estate, over 3 properties that are in the village of Ossining, to which he has not been permitted access and which he believes may well be in violation of the code. Even under our current code, he can do this, and I said, just go to the building department and request an inspection, and he'll go in and see what's going on. But those inspections are permitted, and it's important then that the fire safety inspections are there, and we will have those, within our code. 12033 also has sections that relate to complaints, record keeping, but most importantly, it also deals with a section on violations. Based upon court decisions, including a decision from the Justice Court here, the state revised its code procedure and its rules and came up with Rule 1203.5, if I remember correctly, requiring that these violations must be cured within 30 days. And that is now specific within 12033. You have to have the 30 days. And what our violation can say is that it must be done within 30 days, and we can give you a court date if it's not done within 30 days and prove to us that, in fact, your place has been taken care of. One of the things we propose is the current Housing and Property Maintenance Code has a reinspection provision, and which basically says that before we can proceed with a violation, the building must be reinspected. The proposal here is to put the onus on the entity that has gotten the violation. We're going to give you 30 days to get it done. If it's not done in 30 days, you're going to show up in court. If you fixed it, show us that you fixed it, rather than we have to go out and specifically assert that we have, in fact, re-inspected. We've had situations where we've gone back multiple occasions. Courts haven't viewed that as re-inspection, so this way, that is not there. I should point out that there is no re-inspection requirement specifically delineated in 12033. So it's not as if we're running contrary to 12033. One of the things that we will also include and can include in our violations is that the work must be started immediately, even though we'll give you 30 days to complete it. It's not as if we're going to let you wait till the 29th day to start your work, so that we can get this situation done. I do want to turn for a second to the issue of due process, because this becomes very important, and it's an issue that has been written up in a number of journals and it's come in a number of decisions. And the question is, what does someone do if they get a violation? And currently, or under the state system, there are regional boards of review. And if a party has a problem with a violation, they can essentially appeal to these regional boards of review, and there is a board of review for the Hudson Valley. That board meets every other month. It is probably anywhere from 6 to 8 months from the time you file an appeal till you get a decision. So it's a very time-consuming process because of the number of appeals. I think there's only 3 or 4 people on the Board of Review, and it just takes a very long time. Our current code, in fact, has, if you want to call it a workaround, but something that we can do. And what it essentially is it's a Housing Code Board of Appeals, which we have under Section 16253. It is a 3-member board. Members appointed by the village manager. They serve 2-year terms. And they are, based upon their knowledge, but they would be in a position to make a determination as to whether a violation was properly issued, whether a building was properly placarded. And they can uphold the determination of the code enforcement officer. They can modify it. They can reject it. And I think one of the things that this would permit is a fast resolution of what would otherwise be a very long and drawn-out process. And it does provide for due process. There was recently a court decision from the Supreme Court up in Tompkins County, which is where Ithaca is, where a public nuisance, where a building nuisance statute was ruled unconstitutional because while it provided for a hearing, it didn't describe what the hearing was. And the judge said, I have no way to know, so I'm not going to say that there's any due process here. This would provide for a hearing. It would basically say that within a week they have to notify the building inspector or the code enforcement officer that they want to have an appeal. It would be sent to the Housing Board of Appeals. They would make a determination. We wouldn't call it Housing Board of Appeals. We'll call it something else. And they would make a decision, let's say, within 7 days to 2 weeks, and they would make that decision. If the Housing Board wanted to, they could stay the enforcement of a particular violation until they issued their decision on the appeal. They could also decide not to. The international code mandates that there be a stay. The state has not adopted that part of the code, so we are not so obligated to do that. There is a third alternative in terms of how to deal with this, and the third alternative is to throw it back to the Board of Trustees, and that is that if a person has an issue with regard to a violation, they can advise the village clerk, and the village clerk can send it to the Board of Trustees. The Board of Trustees can conduct a hearing and decide if they want to do that. Not recommending any of the 3, but I think that the Board of Appeals is probably the best way to go. I will say this, that the few jurisdictions that use the boards of review tend to be very small municipalities way upstate. The village of Carthage, and I'm not exactly sure what county that is in, but it is in a county that we probably don't go to too often, and the village of Clyde, another one, which is, I believe, in Jefferson County, of all places. So those 2, but most do not have that. Most have an appeal process by a type of housing board that we're talking about. Further, the board that we have also permits for advisory opinions. If they think that it is necessary to advise on changes in the code, they can so do so. And that board can certainly be reconstituted, I think, fairly quickly if we put information out on the website once the legislation is passed, and we can have that there. It also could be used in the event that there is placarding on an unsafe building, and if the person thinks it is not unsafe, they can act accordingly. And that's where a lot of those sections are. A couple of other things in terms of going through the ordinances and things I just want to discuss that I think have places within this. In Wappingers Falls, up in Dutchess, they have a couple of provisions which I think are of interest, may be of interest to the board, and they deal with the permitting and the certificate of occupancy requirement. In Wappingers Falls, for example, an application for a building permit will not be accepted unless there is proof that taxes, water and sewer bills, garbage bills, fines payable to the village justice court, and all other fees or fines due and payable to the village for the property are paid in full. So that would be a determination before they will even accept it. That's one of their elements in accepting a building permit, that everything has to be paid on the property. They also require there that except where an application is submitted for the purpose of curing existing violations or will result in the curing of existing violations, no application for a building permit shall be accepted, processed, or considered where there is an existing violation of any provision of the village code. And that's Wappingers. And they have an analogous section with regard to certificates of occupancy. Essentially, if you owe any money on anything relating to the property, taxes, we're not going to issue you, we're not going to give you C of O. And that's up there, and that was something that was amended and added there about 8 years ago, a little over 8 years ago, up there. Finally, there is a provision in our current code, 16239, I think, which relates to, oh goodness, it's heavy, which relates to, you should see the one I have in my office. And that one, 16239, actually is reinspection, 16233, which is called inspection before reoccupancy or reuse. This is something I've mentioned to the board before. This is a provision which, as it stands now, only refers to buildings within what's called the urban renewal zone of the Village of Ossining. But it does provide that if a unit within that zone becomes empty, or if it is to be vacant, there is to be 30 days notice of that vacancy given to the building department so that they can then go in and conduct an inspection of that particular location. That does not mean that the unit cannot be rented during that period of time, but it is that the tenant has to be placed on notice that you're going into a unit that may not have been inspected, and you should be aware of that because we could come in and find that there are in fact defects in your particular unit. Whether the board wants to continue with that particular type of restriction is something that can be discussed, and it may be something for another day, but I did want the board to know that that particular section is in there. It's not directly part of 12033, but it's, again, one of the various sections are there. But we will be putting all of 12033 into what will be the new Article 6 of Chapter 162. So that will be administration and enforcement. It will give to the building inspectors and to the code enforcement officers the ability to go out, conduct the inspections. Lynn will talk more about the actual fire inspections and how they're going to be conducted, and hopefully who will be conducting them. But that's, in substance, the revisions that we have here. There are some definitional changes that I've mentioned before that we will be going through to try to have things that are consistent. One of the things that I have discussed with Lynn and with the other folks at the building department is that we need to review particularly our zoning code to make sure that requirements in the zoning code meet the state code, that they are not less restrictive than the state code, because as I pointed out before, if it's less restrictive, it's no longer applicable. So that's an ongoing process to make sure that gets done so that we can at least get to the minimum with regard to certain state code requirements in terms, there's a whole slew of things in terms of all the various codes. But for enforcement and administration, this will provide the fire inspections that will now be mandatory on the triennial or annual basis. They'll provide for the operating permits for those other buildings, and that's where we are.
Well, I'm sure everybody has a list. You seem to sit forward quickly.
No.
Go ahead.
Would you like to let Lynn
Yeah, Lynn has
append, and
been-
then we'll go from there?
Please.
Yeah.
Stuart has covered it so thoroughly, so I'll just go back to the fire inspections. So I think some of you already heard this, but on the triennial inspections, we have a list. We're currently trying to coordinate our list with the assessor's list of the properties that would be affected. Generally, it's 3 families or more. Bear in mind that the way things are classified, the assessor classifies 1 singles, 2s, and 3 families, and then once you hit 4 family or more, it's just classified as a 411. So if you could be a 4 family under a 411, or you could be a 12 unit building. So just bear in mind, so when you say that there's like, say, 250 411s, there could be a lot more units than there actually are numbers of properties are classified. But we've actually mapped out each of those units, each of those properties that would be affected, and tried to fit them into a triennial schedule, and have come out with an estimate of about 6 to 7 inspections in a given week that could happen.
Of properties, not of units.
Properties, yes. You are correct. Thank you.
Make sure I'm following.
Yes. But, and then we've also, that also incorporates not just the residential, the 3 family or more, but 1 or 2 of the annual inspections, which would be public assembly uses, commercial uses, certain commercial uses, and that sort of inspection. Currently, the village building department does conduct fire inspections pursuant to some of the licensing requirements that the village has for restaurants, coin ops, and cabarets. So that would sort of be an addition to it. I'm going to leave it there. Any other questions, and we can address them?
We definitely have some questions. Who wants to go first?
I'm not going to go first. I'm trying to do some math first, so.
Okay.
I go.
Oh, Manny, you never want to go first.
No, shit. Thank you, Stuart. Thank you, Lane. And just so people don't think that I was being disrespectful to what Stuart was talking about, I used my tablet to actually look up stuff while he was talking about, and I went to the Division of Code Enforcement of New York State, which the Village of Austin and the Town of Austin are listed there for the restrictions or how restricted they are in regards to the sprinkler system. And our municipality did this in 1991, and actually the latest one in regards to the sprinkler was Harrison, which they did in 2006. So, and then there's a bunch of other stuff in there where it relates to housing, it relates to fire protection, building and plumbing, C of O's actually, there's demolitions and vacancies and repairs. So I think that hopefully will cover what 1203. Part of what I've always have said before, and which is great, that we actually going to be able to accommodate all this additional information and all these clarifications on our laws for 1203. And something that you mentioned, Stuart, that New York State does have on their building code, you know, what requires a building permit, what does not require a building permit. And that was actually, if you kind of go back, Lynn, I did give a presentation that was done a couple years back and actually lists all that information in there. And if we can update our website for people, residents, and, you know, architects and engineers that want to do any work, to be able to actually see if they require a building permit or not, if they require, you know, architectural drawing, sign, and seal, because there is a minimum standard for that as well, which is, I believe, $20,000 worth of work. After that, you require, if it's less, you don't require sign and seal stamp drawings, but after that you do. And there's a couple other provisions that require architectural or engineering work as well. So I would like all that information that is there to be in our website, because that's a lot of, it has led to a lot of confusion with a lot of people out there, that if you want to replace a window, you can because you need a building permit. If you want to add a railing, you can, one of 2 steps or 3 steps, you can because you need a building permit, because now becomes a structural. So I think some of that maintenance that we need to do, or clarifications that we need to do on our end to clarify that to the public, I think is going to be essential for us to do. So with all these changes, just keep that in mind. And when you were talking about looking at your book, I was looking at that our line 360, and I guess we do need to update some of the sections because they're not correlated the same. So I was a little confused. So.
Right. And the general code folks, I spoke to them this week. If we send our code volumes up to Rochester, once a year, they will basically go through them, make sure they're all up to date, and send them back to us, you know, in correct order. So we're going to do that very quickly.
So that's what I got so far.
Next. Okay.
Go for it.
Now, I was just doing the math on, if you're doing 6 to 7 buildings, I actually thought it was units first, so it's buildings, so even some of the larger buildings for the inspection, so.
Yeah, that would
So,
break down
see, I
even
don't, the
more.
math doesn't work out, to do 6 or 7, I mean, you know, you'd complete 1,092 in the 3-year period, then you have to start again. I don't actually think that adds up to the total that you have to do. So I understand it's based on current availability, and I'm sure you looked at, how many man hours I mean, the average American works 250 days a year, not 365, right? So you have to, I do the math, and I think we need to revisit the math when you're done mapping on your wall, which I know is what you're doing, but it's important because this doesn't even add up, and we're just going to need to be clearer. So that was just a comment, but it's a Herculean feat, long overdue. Glad you're doing it. We may need to add a person or two, and it's like everything else. If we want it done quicker and more, then it's all about people power and how that gets done. So thanks for doing it, but I think it's going to require more. Stuart, the information you just did, I felt like saying amen at the end because it's terrific, and I'm glad you're going to be doing it on a regular basis. From a communications point, do you need more chairs? No. From a communication point of view, if there's any way to take part of this video and actually put it on your part of the site, because when people read the stuff that we look at, what's going to come down the pike, not exciting reading, but hearing what you're talking to, all the stuff's basically online. I think it will be, from a communication point of view, helpful for people. Stuff about, whether we do permits going forward for electricians. I know that's a huge complaint on all sorts of levels. You sort of went through that not so quickly, but there's a lot of stuff, a lot of golden nuggets in what you said. I don't know if there's a way to do it, but maybe Jamie and Paul can look at it. As you go through your ongoing conversation, I would really appreciate that. So there's just a lot in there. I don't want to go through all the points because you're going to bring it up. I'm just concerned, Paul, about straight line math and what we might realistically need. And I don't want it to look like we're over budget. I want it to look like this is what it takes if you want to accomplish X to Y. And let's say what we need in order to accomplish this, because people have been talking about this for years, and it's a big topic.
Agreed, understood, and to remind the board and the public, we presently have a vacancy in there for
Yeah.
the inspector role right now, but we all discussed internally we do not want to hire anybody new until we really get our logistics in shape.
That's it for me.
Stuart, that was magnificent, I would, if there's such a thing, to talk about that. No, I can really appreciate your articulation of all the different elements of the code. I think that there's a couple things going on here. One is sort of this reconciliation or sort of analysis of our current land use code versus state requirements, which I kind of see as something separate from the promulgation of the other codes that have to do with enforcement. So I guess I would want to get a better understanding of that process, how long it's going to take to do that. If our current code is not in compliance with state regulations or state land use code, what that's going to be about. It sounds like we're going to be doing this is going to be a pretty major piece of legislation, so, because we're going to adopt all this stuff, right? I mean, that's the idea. We're going to adopt, we have to go through a legislative process to adopt it into our code, or does it just sits on top of us now?
No, it would have to be a formal, adoption, so it'd be public hearing and everything like that. It's not simply because it's 1203, you got to follow.
Right.
We would, you would adopt it.
So I guess would the strategy be to would there be a certain order to do different sections, or would you recommend doing the whole thing? What's the roadmap?
Let me, John, if I can answer the first part, which
Okay,
is
sure.
related to the other sections of the code. Lynn and I have talked about this a bit, but that is of that's of great importance, because what we cannot have are provisions of the code which are in fact less restrictive than the state's. I had a very lengthy conversation with a senior attorney at the Department of State a couple of weeks ago who was very helpful, but part of that was that when she said, "Oh, I've been looking at the Village of Ossing's code," and I said,
Okay.
I said, "Okay, thanks." So it will be important that we get those sections down quickly, because obviously it's important from a planning perspective, it's very important from a zoning perspective. And it's important for our code enforcement folks who go out there, because, you know, effectively, we have been and we need to use the state code, but in terms of, if someone is coming in, and Lynn may be able to talk better to this, coming with a set of plans, which is based upon, let's say, what we have in Chapter 270, but the state says this, we want to make sure we're where they are. That's why I brought up the issue of the sprinkler system, because back in 1990, what we put in was essentially state-of-the-art in terms of that, and we just want to make sure we are where we need to be with regard to that. In terms of the second area of your question, what the proposal is that the legislation would, right now, would involve the minor amendment to Chapter 91 to make reference to the Energy Code, amendment to Chapter 95 to include it as the unsafe building and demolition, removal of the licensing standards for electrical under Chapter 114, and then the significant amendment to Chapter 162, which would put in the enforcement and administration section, the new chapter, the new Article 6. That would be this time around. It will still be a work in progress, because I'm sure that as we go through, we will find definitions of certain things that have to be changed and things that have to be revised. But that's overall, I think, the first thing to do, because of critical importance, is to get 1203 out there and get those inspections started as quickly as we can. And to go to something that Trustee Levin was mentioning, I think it's very important. For example, with regard to operating permits, these are brand-new inspections that are going to start. So the limited number of venues that are under that need to know what that is. There may have to be a phase-in time, so that because they're going to have to do a permitting process, and we're going to have our people go out and do those inspections. So there will have to certainly be an outreach to those folks to make them aware of the fact that this is what's coming. Same with the fire inspections, you know, regardless of who's in the first, you know, 1/3, you know, triennial or whatever. But to get 1203 and these other, you know, amendments in there. I mean, the electrical, I think, is fairly straightforward. We just take out the licensing requirements because we don't license anymore. But getting the 1203 is particularly important, so that we can get that in there. And also, to be blunt, so that when new violations are written, they're written in accord with this. And so therefore, if an action is brought ultimately in justice court, we're working under 1203 and under these new requirements.
So do you, I mean, you've laid out a lot here. I mean, do you have a timeline? Do you have a, I mean, what do you?
The plan, hopefully, and that's my plan, is to, as to what I've discussed tonight, to call for a public hearing, to have the resolution to call for a public hearing next Wednesday, which would be the 1st, the public hearing to be on the 15th, and then the first Wednesday in April would be the legislative session to pass the legislation. So that's the timeline. So the resolution next week would be for the public hearing, and then it would simply follow from there. And it will be available for the public to look at, so that everyone will see where the changes are. It will reference the other sections of the code, so that they can go back and forth and see what those changes are. But that's the plan rollout.
But that scenario is for the Uniform State Code, right?
That would be for the Uniform State Code, the minor revision to Chapter 91, the unsafe building, and the electrical. So that would be those 1, 2, 3, 4 sections. So those 4 areas would be contained within this. Correct.
Okay. And the land use element of it.
That's something I have to sit down with Lynn to go over that.
Okay.
I think what's needed there, and it's something I think we have to talk to our state rep on. If our code is in some ways less restrictive than the state, it may be that all we need to do is just basically insert the state code. It may not require a new ordinance because the state code's there. Also, I should point out, if our code is more restrictive than the state, we're going to have to ask the state for permission to use the more restrictive code. And the way it works is, you're permitted to use the more restrictive code unless the state says no. So that's something we would have to look at. But the key, I don't think that it would require a legislative change if we were less restrictive, because we're simply then, by Chapter 91 and by 162, the new Article 6, we'll be adopting the full state code. So we'll be adopting every section of the state code.
Question, Lynn. So you've already mapped out how many inspections you think you can do per week. That's like 6 per week.
Yes,
So that's 6 properties?
yes.
Okay, and so just for the sake of a question, what actually entails a fire inspection? Like, what are you looking for?
So if it were a 3-family residence, we're looking at the common hallways, the egress, the panic hardware, the fire safety.
Like
That
sprinklers and all
there's,
those?
if it's required, yes.
Okay.
Depending on when it was constructed, yes.
Okay. So that's like 6 per week, though. So, yeah.
That's what I asked.
Yeah.
Based on their
Current manpower. Okay.
Right.
So that's basically like if it's an apartment building, that's 1 person for that day.
Right, it depends.
Okay.
So right now, we've mapped, the larger apartment buildings are not on the earlier side of it,
Gotcha.
but that would come down differently.
I have one follow-up that wasn't, you went into the Board of Appeals
Yes.
discussion. That's not part of one of the sections of the legislation, that's something you're bringing,
Right.
that's a separate conversation, or is that a part, how does that fit into a timeline? We don't have one today. Is that just like we create other boards, and the
plan-
village manager appoints, I heard that part, but
Right.
it's,
Under,
does that have to wait for the rest of the stuff?
No,
Is it on a parallel path?
no,
Do we have
I-
to decide about it separately?
what I would like, what I think would be preferable is to make it part of what we're doing here. Because that way, if a violation is issued, the person can know that they can go to this board. Now, it's gonna require that we get the board up and running fairly,
Yes.
quickly. Sort of the same way that we got, people who are involved with the others, that we have now. But, there are, as I said, in our code now, we have a provision for that, what we call, a Housing Code Board of Appeals.
What section was that,
When's the
Stuart?
last time we had one?
We have, trustee Kazad, sections 16252 to 16254. And it's a 3-member board appointed by the village manager, each for terms of 2 years. It can have its own procedures.
That's already, so the skeleton is already in there?
Yes, that is correct. That is correct.
All right,
Well,
something else to think about.
Well, my only question would be is if we haven't constituted that board yet, and somebody wants to make an appeal, where's the due process?
You raise a fair point. At
I
this
mean, I don't expect you to have an answer, but I mean, if this exists in our code, I mean, this is the first I'm hearing of it, so,
It is-
I confess I've not read that book.
Okay.
In its entirety, so, yeah, well, apparently, but,
It's great for a filibuster.
yeah. But, no, at the end of the day, we've got something in the code, and if somebody wanted to appeal, would they come before the Board of Trustees in a pinch? I mean, it says that,
It actually does not provide for that. It simply says, any person, owner, corporation who feels they're aggrieved with the ruling or decision of the enforcing officer may appeal the decision or interpretation to the Housing Code Board of Appeals. I mean, that's what it says. So it doesn't have a default that it would go to you folks. Since this is in the code and has been in the code for a while, it may well be that one of the things the board may want to consider is just getting people on that board now, and doing that. But I think certainly, particularly given the due process as relates to building code violations and placarding and entering buildings, is a very big issue with a lot of courts. It's important that we have it, spelled out, and that it be there. Yeah, as I said, as Trustee Levin said, the skeleton's here, so we can do that. I think the point is well taken in terms of where we currently, but you know, there is a right of appeal here, and this way we'll also make sure that the people are aware of it, that if they have that issue, you know, they can do that, because hopefully it will resolve a lot of issues before they have to go any further.
Well, I mean, I guess my concern is, you know, in the, I mean, we're gonna have to constitute a board here, so, I mean, in the absence of that board, do they have to go to this state?
If they, currently, if they have an appeal, they would go to the State Board of, Regional Board of Review. That's
Which
what.
takes 7 months to get
Which
processed.
which, yeah, can take, yeah, easily 6 to 8 months, correct. But that would be, if you want to call it, for want of a better term, the default process of doing it. And I think just because
I guess
everyone
I'm just saying, in the absence of, you know, of the constitution of this board, I would hate to have a violation like that have to wait for 7 months to be adjudicated. I just think that that's, you know, is there any way, you know, is there any interim situation in which at least the Board of Trustees could hear these things, at least until we're able to constitute the board?
I will look into that.
I wouldn't want
Let's
to do that.
constitute the board.
Yeah, I
Well,
wouldn't.
I'm just saying that, you know, having a violation going on for 7 months, I
Okay,
mean.
but the
I'm
thing
just-
is, what okay, so, let me just, I'm gonna comment on that and we can wrap it up. We've been talking about this for a while and I still have a list of things to get through. So can I just give my thoughts as part of my comments here? So I wanna just say, Paul, thank you for opening up this discussion by sharing that report from the code enforcement officer. Obviously, we are aware of some of the very dangerous situations that our frontline workers, staff are facing, and I think it's important that other folks know what's really going on and why we're spending so much time working to clean up and strengthen and align our codes to ensure the safety of the folks in our community. And on that note, I want to say, Stuart, it's less than 2 months that you've been here, and thank you. You've shown an incredible dedication. Your approach is extremely thorough and collaborative with the other departments, in this case really focusing on the life safety issues that are facing us in the community. So I have a couple more things on my list, and then I'm going to look forward to next week's call for a public hearing, and I know we'll have more opportunities every time these topics come up to revisit and ask more questions that we have arise over the coming week and weeks. I'll pick up on the appeals board question. Maybe you know, because you've got the thing open in front of you, but the way that it's written, are there any qualifications required, residency required, any recommendation of the skill set of the people? Are we hoping there's at least one lawyer? Do we care if they know anything about real estate or construction, or is it just they need to live in the village? It'd be nice if they knew where the village was, you know. Usually there's a residency requirement for something like this. So while we're figuring that out, I'll just,
It doesn't have any of that.
okay. So then I would just say, there is a due process. The system is in place. There's a court system.
Right.
But what this could do, if it were constituted, is it could streamline what actually gets to the courts. Because the point of the appeals board would be if a property owner says, this violation is inappropriate, I don't think I should even be held to this, then the appeals board would review it. But correct me if I'm wrong, if my misunderstanding is inaccurate. The appeals board could look at it and say, hey, you know what, you're right. This violation is not warranted, either the way it's written or what it is. And then our staff and the courts don't have to deal with it. So we've just taken something out of the stream.
Right.
Hopefully not something that's a life safety issue, but that we'll be able to revisit in a way that's really going to succeed at getting the compliance that is necessary. So I would look for us to be able to constitute it as quickly as possible, because I think it could actually be helpful for us to streamline this process. You said that schools are exempt from inspections. Is that just public schools or is that all schools? Do you know?
I believe it's just public, but I think it goes through DASNY.
Okay. And it was interesting, it seemed like there were just a couple of communities that had, they would not issue building permits or certificates of occupancy if the property had any outstanding fees or taxes.
Wappingers Falls.
So that's the only one?
There are others, but
There are
they-
others. That was one of the model
They
legislations.
they
Okay.
explicitly put that into their enforcement and administration under building codes. I've come across a couple that have done that, but they have it most explicitly in theirs with regard to both.
It sounds like a great idea, but I would be interested to know what the unintended consequences might be, and if we're looking to legislate something that is really a problem, or if we're just legislating something because it sounds really good, because
No.
that way we make sure the village gets paid.
Again, it's not required under 12033, so it can always be something that we can talk about and then put into at another time.
Okay.
But it's something that's in a particular code in a fairly close jurisdiction.
And Mayor, before you go down your list, and Stuart can correct me, but I just leaned over to ask him, the more prevalent benefit of the
Appeals board?
the appeals board, thank you, isn't finding something that shouldn't be going to the court because it has no merit. It's they can actually process and come to resolution and settlement and keep it out of the court, which is going to be
Love it.
a much more efficient way, I think, to
Excellent.
One of the things we learned with the other board is when you have that in place, like the landlord tenant.
Turn your mic on.
Well, one of the things we learned that Quantan and I looked at when we're looking at landlord-tenant is that when you have that in place, the court system, having that in place, actually prefers that citizens use that and therefore give it more credence, gravitas, whatever you want to call it. So it's got some real nice benefits to it, as we've learned from another project that we're working on.
So if the choice was the regional 6 to 8 months option, constituting a local board, or making us listen to it, I go with choice B. And I think that's what you did not recommend, but recommended. Then my last question, and maybe this is one of the things that I just haven't assigned it to its name, but when you referenced the vacancy notice, the 30-day notice that when there is a vacancy that allows for an inspection, I don't know if it requires an inspection or allows for an inspection, but it seemed like because, were you suggesting that with the way that is written, it's referencing the economic renewal zone, urban renewal zone?
Yes.
Were you
Specific-
suggesting that that be expanded to the entire village?
The thought would be that you would delete the urban renewal language and expand it rather than keep
To what?
the specific.
For the whole village?
It could be the entire village. It could be any multiple or anything that
Are
comes
we
within the-
required to inspect every vacant apartment within 30 days of its, if we're notified within 30 days, are we then required to inspect each one? Because that seems like a great idea to have the ability to, but I don't know how we would, be able to hold landlords accountable for the
Right.
notification within 30 days, and that if they don't, then what? And if we're requiring our building department to inspect everyone, although I really like the idea, I'm just wondering if that's feasible, and I don't like to pass laws that I know we can't enforce.
Well, and that's something to look at. It is a section, again, at this point, it was referring specifically to the area encompassed by the Ossining Urban Renewal Agency, and it does provide that the same meaning the unit, shall not be reoccupied and reused for residential purposes unless an inspection made under the provision of this chapter at a date not more than 30 days prior to the dwelling unit so becoming vacant. So what you'd need is you'd need your landlord saying that it's becoming vacant, then you'd have to have someone actually go out and conduct the inspection. But it's interesting, what it also has there is that it provides that prior to the time when a dwelling unit subject to the provision of this section is to become occupied, the tenant is to be provided with a document in a 12-point type saying that the dwelling which you are about to occupy is subject to the provisions of the Housing Code of the Village of Ossining and may not lawfully be occupied unless it has been found free of violations of the code. If it is occupied in violation of the code, the tenant may be subject to removal. Records relating to the dwelling unit may be examined at the building department of the Village of Ossining. So, in other words, it doesn't mean the landlord couldn't rent it, means it, but it does impose, it does call for an inspection. And so it may be something that the board wants to consider, is while it sounds good, first of all, how do we get the compliance from the landlords? And number two, once we get the compliance, are we going to be able to basically get someone in there? Lynn and I were talking earlier
Well, there's a
today.
third piece. Somebody's moved in. How do you get rid of that poor person who doesn't,
Well, that's,
who's,
That's
now
true.
living there.
That's true.
For
And-
30 days or
And,
whatever.
and one of the things that Lynn and I were talking about is what if a unit basically becomes vacant 4 or 5 times in a year? I mean, you just, you know, you're gonna keep potentially going back to a unit to see what's going on. You know, how many inspections? There may have been a very specific reason why this was passed with regard to the urban renewal zone. I have seen this particular type of language in other municipalities that does not limit its restriction. But again, that's something that the, you know, for the board's consideration as to whether it's something that needs at this point to remain in 162, in Chapter 162. You know, at this point. It's there now, but, you know, clearly, since we're not using the urban renewal zone, it's sort of there without any impact.
Great. I think we have a couple of quick ones, right?
No, it's great. We are on schedule, what do you mean?